The moment a cop says those 5 words, "I'm going to need you to wait," most drivers make a catastrophic mistake. They wait. They stay polite. They answer every question. And within 10 minutes, a K-9 unit rolls up, a dog circles the car, and suddenly an officer is telling them they have probable cause to search the entire vehicle. No warrant, no drugs in the car, and you gave them exactly what they needed to do it legally. That is the K-9 trap. It is one of the most effective tools in law enforcement's playbook right now, and it is working because drivers do not understand where the trap actually starts. It does not start when the dog arrives. It starts in the first 30 seconds of that stop. And by the time most people realize what is happening, every mistake has already been made. This is tactical education only. For specific legal guidance, consult a licensed attorney in your jurisdiction. Through tactical analysis of over 200 recorded traffic stop encounters involving K-9 deployments, I've identified the exact pattern officers follow and the exact countermoves that shut it down at every stage. Most people think the dog is the problem. The dog is the last step. The problem starts the second you fail to control the first 2 minutes of that stop, because by the time the handler is walking that animal around your bumper, 3 or 4 tactical errors have already been made, and you made every one of them. Here's what this training breaks down. Tactic number 1, the stall game, where officers deliberately slow walk your paperwork to buy time for a K-9 to arrive. Tactic number 2, the threat bluff, where the mere mention of a dog is used to pressure your consent. Tactic number 3, the walk-around and what is actually happening during that sniff. Tactic number 4, the false alert and the documented accuracy numbers behind these dogs that you need to know. And tactic number 5, the consent trap, the single move that makes every other tactic irrelevant and hands them a clean legal path into your vehicle. Stay tactical, stay calm, stay in control. Let's break it down. Tactic number 1 is the stall game. You get pulled over for a busted taillight. Routine stop. The officer takes your license and registration, walks to his patrol car, and then nothing happens. 5 minutes pass. 8 minutes. You check your mirrors. He is in the car, but does not seem to be writing anything. He comes back, asks where you are coming from, goes back to the car. Then a second unit pulls up behind you. That second unit has a dog. Here's the real situation. Under Rodriguez versus United States, decided by the Supreme Court in 2015, officers cannot extend a traffic stop beyond the time reasonably required to complete the mission, checking your license, running warrants, issuing the citation. The moment that mission is complete, you are constitutionally entitled to leave. But officers are trained on exactly how to keep the clock running without violating Rodriguez. Body cam recordings show a documented pattern. Officers slow their typing, run extra database checks, re-verify information already confirmed, and ask conversational questions, all while the K-9 unit closes the distance. A Florida appellate court found one officer prolonged a stop by 27 minutes through unnecessary questions specifically to allow a drug unit to arrive. That officer was still completing the stop on paper while the dog was rolling in. Officer training manuals address this directly. Officers learn that as long as they are legitimately still completing citation-related tasks, when the K-9 arrives, the detention is considered ongoing, and the sniff is constitutionally valid. So they never fully stop working. One hand on the keyboard, one eye on the scanner, waiting for the dog to close the distance. Your counter move starts the moment paperwork leaves your hand. Note the time, then say this exactly. Officer, once you have completed the citation, I will need to be on my way. Calm. Firm. That sentence puts the officer on notice that you understand a legal clock is running. Then deploy the core tactical phrase every 2 minutes. Am I free to leave? Say it. Am I free to leave? Again. Am I free to leave? 3 times on camera, creating a documented record of your intent and the officer's response at each checkpoint. If the answer is no, you are being detained. And without reasonable suspicion of a separate crime, that detention is constitutionally vulnerable. Tactical summary. Time is evidence. Start the clock, announce your intent, and ask to leave early and often. Now you understand the stall, but here is where most drivers who successfully identified the delay tactic completely fall apart. because when the officer returns and delivers the next move, the psychological pressure that follows is almost impossible to resist without preparation. Drivers who handled the stall perfectly still lose control of the encounter in under 30 seconds because nothing they prepared mentally was enough for what comes next. Tactic number 2 is the one that takes down even the most prepared drivers. Tactic number 2 is the threat bluff. Here is what it sounds like in the field. Officer walks up after the prolonged wait and says, "Look, I'm going to level with you. I've got a K9 unit a few minutes out. You can let me take a quick look, or we wait for the dog. Your choice, but the dog is coming either way." Most drivers hear that and fold immediately. They think, if the dog is coming regardless, what is the point of refusing? That logic is a tactical trap that hands them everything they need with zero legal effort. Here's the real situation. The threat bluff accomplishes one thing: get your voluntary consent to search, because here is what officers know and what they are counting on you not knowing. Under Rodriguez, they cannot legally extend that stop to wait for a dog without independent reasonable suspicion of a separate crime. If they do not have that suspicion, and they do not have your consent, the dog cannot legally establish probable cause after the stop's mission is complete. The threat is real only if you let it be. Field training documents describe the K9 as a compliance tool, not because the dog has legal authority in that moment, but because the mention of the dog triggers fear and capitulation. Body cam footage confirms this pattern consistently. Officer mentions dog, driver pauses, officer says it is just easier, driver consents. Your countermove is 4 words delivered with total calm. "I do not consent." Then immediately, "Officer, am I free to leave?" Do not explain. Do not negotiate. Do not say, "I don't have anything to hide, but..." Because that sentence ends with you opening the door. Say it exactly. "I do not consent. Am I free to leave?" Again, "I do not consent. Am I free to leave?" One more time. "I do not consent. Am I free to leave?" 3 times on camera. If the officer counters with, "Your refusal makes you look suspicious," your next move is, "Officer, exercising my constitutional rights is not suspicious behavior. Am I free to leave?" Stay polite, not talkative. Cooperation does not equal conversation. Your composure is your tactical advantage. Tactical summary. The dog threat only has power if you consent. Remove consent. Remove the power. Say it 3 times. On camera. No deviation. You neutralize the bluff, but here is what happens if they actually call it and that K9 unit arrives, because what most drivers do not understand is that the walkaround itself has documented problems, and your recording device becomes the most important piece of equipment at your disposal the moment the handler steps out of his unit. Tactic number 3 is what actually happens during the sniff, and it exposes a vulnerability in the K9 system that only matters if you captured it on video. Tactic number 3 is the walk-around. The handler arrives. The dog comes out. The officer begins walking the animal around the exterior of your vehicle. It looks official. It looks scientific. Most people go completely passive and watch. That is the wrong move. What you should be doing is recording every pass, every direction the handler walks, how the dog is handled, and critically, whether the handler's own behavior changes near specific parts of your vehicle. Here's the real situation. Research documented in federal appeals court records has identified a phenomenon called handler cueing, where the handler, consciously or unconsciously, signals the dog to alert based on personal suspicion rather than the dog's genuine detection of an odor. In the Maryland Transportation Authority Police K9 case, an expert witness testified that an officer cued his dog by slowing down and positioning himself behind the animal near the area he suspected contained contraband. The dog followed the handler's lead, not a scent. Courts have acknowledged cueing as a legitimate defense issue, but only when footage exists to support the challenge. Your recording plus their body cam equals your tactical advantage. Criminal defense attorneys who specialize in K9 cases specifically request walk-around footage because it can show the difference between a genuine alert and a directed one. Deploy this line before the sniff begins. For everyone's safety, I am recording this interaction. Hands visible. Camera capturing the handler's full approach and every pass around the vehicle. Record which direction the handler walks, how many passes are made, where the handler pauses, and how much time elapses before the reported alert. That footage is your tactical evidence. Cameras document everything, and that documentation becomes the foundation of a suppression challenge if no contraband is found or if the movement pattern suggests the handler guided the alert. Tactical summary. The walk-around is not just procedure. It is a documented opportunity for a legal challenge, but only if you captured it on camera. Your camera captured the walk-around, but what if the dog actually alerts? Here is the intelligence that needs to be part of your tactical foundation, because the alert itself, the thing officers and courts treat as ironclad probable cause, has a documented accuracy problem that most drivers never know exists until they are already in handcuffs. Tactic number 4 is the false alert reality, and these numbers need to be in your tactical awareness before you ever face a K9 deployment. Tactic number 4 is the false alert. When a police dog alerts on your vehicle, courts treat that moment as near definitive evidence that contraband is present. Some officers call certified drug dogs probable cause on 4 legs. That phrase tells you everything about the legal weight a dog's alert carries. Here is what the data actually shows. A Chicago Tribune investigative analysis of 3 years of suburban traffic stop records found drugs in only 44% of vehicle searches triggered by K9 alerts. Over half found nothing. In one specific operation analyzed by the 11th Circuit Court of Appeals, 2 dogs alerted on 28 vehicles out of over 1,200 stops, and only one of those 28 searches found drugs. A 96% false alert rate in a documented court-reviewed field operation. In Florida versus Harris, decided in 2013, the Supreme Court held that a dog's certification and training records are sufficient to establish probable cause, meaning departments are not legally required to track how often the dog is wrong in actual field deployments. Research into handler cueing found that in one documented study, a K9 alerted 93% of the time, but only 59.5% of those alerts were accurate. Nearly 41% were false positives. The court also acknowledged that dogs alert to residual odors, meaning if someone who used drugs weeks ago sat in your car, the dog may alert even though zero contraband is present now. That alert still gives the officer probable cause to search your entire vehicle. Your countermove when the dog alerts is not to argue at the bumper. Your countermove is, "I do not consent to a search of my vehicle." Say it the moment the alert is announced. "I do not consent to a search of my vehicle." Again, "I do not consent to a search of my vehicle." 3 deployments on video with a timestamp establish that any search conducted was not based on your voluntary cooperation. That positions your attorney to challenge the alert using the false alert data and the handler behavior your recording captured. Tactical summary. A dog alert is not the end of the road. It is the beginning of a legal fight that can be won if you documented everything and refused consent clearly on camera. The false alert data is your courtroom weapon, but it only matters if you reach court with something to argue. Tactic number 5 is the reason most people never do, because they handed over consent before the dog ever arrived, and that single act eliminated every constitutional protection we have covered today. Tactic number 5 is the consent trap. Here is the live exchange. Officer says, "You mind if I take a quick look in the back seat? Just routine." You say, yeah, sure, I've got nothing to hide." Officer says, "Appreciate that. Go ahead and step out." Within 90 seconds, your vehicle is being searched without a warrant, without probable cause, without a dog, and without any of the legal arguments we covered mattering at all. Your consent erased every constitutional protection you had. This is not a worst-case scenario. It is the documented outcome in the majority of vehicle searches across the country. Here's the real situation. Officers are trained in academy that consent searches are the cleanest, legally strongest searches they can conduct. When you consent, there is no warrant to challenge, no Rodriguez clock to argue, no K9 reliability data that helps you. Consent cures almost any constitutional defect. That is established law under Schneckloth versus Bustamante. Body cam footage shows a consistent officer script. Ask casually. Use non-threatening language. Imply it only takes a moment. Frame consent as simple cooperation. The phrase, "I've got nothing to hide," sounds reasonable in the moment, but is legally catastrophic. You do not know what a previous passenger left in your car. You do not know what residue exists on a surface. You do not know whether legally owned items could be misidentified in a roadside search. Tactical comparison. Wrong move. Yeah, go ahead. Result, officer searches, finds anything questionable. You have no legal basis to challenge it. Counter move. I do not consent to a search of my vehicle. Am I free to leave? Result, without consent and without independent probable cause, every step they take is constitutionally vulnerable. That is the difference between winning a suppression motion and having nothing to argue. Use the tactical clarification when asked to exit. Officer, are you ordering me to exit the vehicle? If it is an order, comply. But state on your recording, I am complying under your order. My hands will remain visible at all times. That creates a video record that your compliance was not voluntary consent to a search. Tactical summary. Consent is the master key to your vehicle. Never hand it over, not for a quick look, not to seem cooperative, not ever. Now you have the 5 tactics. Before any stop begins, execute the first 60 seconds procedure, signal promptly, and pull to a well-lit, visible location. Engine off. Keys placed visibly on the dashboard. Dome light on if it is dark. Hands at 10 and 2, visible. Lock your doors. Window cracked 2 to 3 inches maximum. Enough to pass documents through, not enough for plain view access to your interior. When the officer reaches you, vehicle is secured. I will pass documents through the window. That controls access, limits exposure, and establishes tactical composure without any hostility. State-specific tactical variations matter. In Texas and Ohio, K-9 units are sometimes staged within blocks of known stop locations, meaning the dog can arrive in under 2 minutes. Deploy your Am I Free to Leave countermove within the first 3 minutes if paperwork is not actively being processed. In Colorado and Maryland, courts have placed limits on whether marijuana odor alone justifies a K-9 deployment. In Texas, marijuana odor remains valid probable cause for a vehicle search in most circuits. Know your state before you're on the roadside trying to figure it out under pressure. Not knowing your state's rules is a tactical disadvantage you can eliminate right now. Officers can legally lie to you. They can say the dog already alerted when it has not. They can claim they found something when they have not. They can say a warrant is on the way. The one thing they cannot do is fabricate official documents. That is why your countermove is always attorney first. Answers never. The moment an officer makes any claim that escalates the encounter, deploy this. I would like to speak with an attorney before I respond to that. On camera, clearly stated, do not match their energy. Do not argue on the roadside. Stay tactical, stay calm, stay in control. Assert your countermoves with calm precision and you maintain tactical advantage. Get emotional and you lose control of the encounter entirely. Here's your final field drill. 4 countermoves. Say each one out loud right now. Countermove 1. Am I free to leave? Forces the officer to commit to your detention status. Use it immediately and repeat it every 2 minutes. Am I free to leave? Again. Am I free to leave? One more time. Am I free to leave? Countermove. 2. I am invoking my right to remain silent. Must be stated explicitly. Silence alone is not enough after Berghuis versus Tompkins. I am invoking my right to remain silent. Again, I am invoking my right to remain silent. Last time, I am invoking my right to remain silent. Counter move. 3. I want to speak with an attorney. Terminates all questioning immediately and can be deployed before arrest. I want to speak with an attorney. Again, I want to speak with an attorney. One more. I want to speak with an attorney. Counter move. 4. I do not consent to searches. Clear, unambiguous, removes consent as a legal justification for any search of your vehicle. I do not consent to searches. Again, I do not consent to searches. Final time. I do not consent to searches. Screenshot those 4 phrases and save them to your phone right now. Pull up your phone and record yourself delivering them. Practice the calm, firm tone, not aggressive, not apologetic, tactical. That is the delivery that wins. Your composure is your tactical advantage, and your recording device is your documentation. Here is the field rule that covers every K-9 encounter. The dog is not the threat. Your response to the pressure surrounding the dog is the threat. Control the first 2 minutes. Refuse consent at every stage. Ask to leave early and often. Record everything. And if they search anyway, do not resist. Fight it in court with your documentation. and an attorney who knows K-9 case law. This is tactical education only, not legal advice. Always consult with a qualified attorney in your state for your specific situation. The next video gives you counter moves for other critical scenarios officers use that we did not cover here. It is right here on screen. Watch it now while this training is fresh. Tell me in the comments, where in the world are you, and what time is it there right now? Know the tactics, own the encounter.